Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont v. Justin Travers, representing a case number 24 AP 055. Representing the appellant, Justin Travers, is attorney Rebecca Turner. Representing the appellee, State of Vermont, is attorney Robert F. Plunkett.
All right, appellant's counsel, please introduce yourself and your client, and you may proceed with your argument.
Thank you, Your Honor. Attorney Turner representing Mr. Travers, who's appealing his conviction for misdemeanor DUI refusal. The sole issue here is that there was insufficient evidence on the specific element that the trial court bifurcated on. And the issue here is whether or not there was sufficient evidence of a prior DUI conviction pursuant to the details set out in the refusal statute, establishing jurisdiction, establishing driving on a highway under the influence of alcohol, and paralleling at least the 23 VSA 1201. The arguments as set out in the brief established this wasn't done, that the bifurcated trial, as followed here, followed a long tradition of providing due process protections for a defendant so that this issue wouldn't be and expose the jury to something that could bias them based on prior conviction. Ironically, this bifurcated proceeding used here cut corners on Mr. Travers' constitutional rights, and that's mainly the due process right. He was asked to waive his right to a jury trial. That was non-compliant with the criminal rules 23, and even if you could find piecing together an explicit, intelligent waiver of his right to a jury trial, there was never on this record a knowing, intelligent waiver that the judge would find this element beyond a reasonable doubt. This was a strange and albeit trying to create some efficiencies, I believe, around collecting Mr. Travers' admissions, which were never admissions to the required facts of this element. And the state's argument this was invited error or waived by counsel has to fail. This is a personal waiver from Mr. Travers himself. Attorney cannot waive this on his behalf, and not just the right to a jury trial. Again, the fundamental due process presumption of innocence right, that the state has a burden beyond a reasonable doubt that a fact finder, whether it's the judge or the jury, find this element, not a sentencing enhancement, which the trial judge incorrectly told Mr. Travers repeatedly that this wasn't the issue, again, confusing the matter as to what was happening at the moment before the jury brought in the verdict on the other elements. Given that there was never a verdict on all the elements by a fact finder beyond a reasonable doubt, no matter what Mr. Travers said in this record, cannot be enough under this court's clear precedent. Unless there are other questions, I'll reserve the remainder of my time for rebuttal.
All right, seeing that there are no other questions, you may reserve your time, and then we'll call on the counsel for the appellee. Please introduce yourself, your client, and you may proceed.
Good morning, Justices. I'm Rob Plunkett, Deputy State's Attorney, Bennington County, representing the state of Vermont. Quite frankly, this case can be disposed of fairly quickly in either of two ways. One I'd focused on was the invited error rule that here was exactly as Ms. Turner said. The process was shortcut, but it was by her client. One thing I did overlook was that there is a case that's more directly on point regarding the DUI refusal. It's State v. Alzaga, 2019 VT 75 in paragraphs 25 and 26. That's more directly on point regarding a DUI refusal than State v. Morse is, but either way, it could be disposed of fairly quickly that way. However, there simply was not error here. As I had noted in my brief, there appears to be no specific procedure in Vermont for stipulating to either an element or perhaps an enhancement. Here, what happened was a plea colloquy without the actual specifying that it's a guilty plea, which would not make sense when it's just one element versus the others. So the court here can simply find that a Rule 11 colloquy is sufficient for a stipulation to an element of the crime without needing to go to the invited error rule. And here it did happen, and I'm surprised Ms. Turner says again that her client did not admit to the element. He did. It's in the transcript, and because of that, the conviction should be upheld. Thank you.
All right, thank you. How much time does the appellant have remaining?
Appellant has 1 minute, 58 seconds remaining.
All right, Ms. Turner?
Thank you, Your Honor. The devil is always in the details when a client is being asked to make admissions that will supplant the state's burden of proof, and we have extensive precedent from this court in the context of a Rule 11 challenge. As the attorney for the state has to concede, there is no procedural exception to a guilty verdict by plea, where all the protections are in place to make sure that the defendant's plea is knowing, intelligent, and voluntary, or we have a verdict, a conviction found by a fact finder. And the fact finder is two ways, a bench trial or a jury. And here we don't have an intelligent waiver of a bench trial that happened here. Now, I haven't had a chance to review in real time the Elzaga paragraphs referenced here. I think the court has to reject outright the invited error argument, whether or not the invited error is seen from the defense counsel's perspective or Mr. Travers himself. This record does not reveal that he knowingly had the context of the consequences of what he was doing. In fact, he went in thinking that this was going to be a bench trial. That was clear. In real time, you can see that he is making statements that defense counsel is responding to, and the court, and these two attorneys in the room, and the state is in the room, are adjusting and determining, oh, this is changing into a stipulation environment. At no point is there a break. At no point does the court engage in a direct colloquy with the client, asking him what he is in fact understanding and reviewing. At best, we have very summary discussion about a jury. Now, the point about looking at this record, I do encourage this court to dissect the record for even to look at the statements and whether or not they establish the elements. I see that my time is out. Thank you.
Right. Thank you both very much. The court will take the matter under consideration.
Thank you.
And may call a conclusion of this case, please.
The next hearing for the court is scheduled